Delivery of order, item number 1.
For reasons mentioned in the order, this miscase is allowed and the interlocutory application number 2008 is restored to file. The registry is directed to list the said interlocutory application in the next week on a date to be fixed by it.
Grateful. All right.
Item 2.
For reasons stated in the judgment, this court finds no ground to interfere in the impugn orders dated 8/2/2024 as well as 26/7/2024, except to the extent that the name of the newly impleaded defendant, Kulendra Deka, shall be shown as defendant number 2 in place of Manavendra Deka, and the name of earlier defendant number 7, Kalindra Deka, shall be retained in the plaint as well as in the counterclaim. The stay granted earlier shall stand vacated. The trial court shall proceed with the suit in its usual course.
3.
For the reasons mentioned in the order, this court is of considered opinion that for any scheduled offense under National Investigating Agency Act 2008, even if the investigation is conducted by the state investigating agency, the special court under the said act has the special exclusive jurisdiction to try the cases. And under the statutory provision contained in the said act, any order of rejection of such bail, rejection of bail by special court is appealable under Section 21(4) of the National Investigation Agency Act. And as such, this court is of considered opinion that an application for bail under 483 is not maintainable. However, the question now remains that whether the instant bail application can be treated as an appeal under Section 21(4). This court is of considered opinion that since for filing of an appeal under Section 21(4) of the said act, a period of limitation has been prescribed under Section 21(5) of the said act, it would be appropriate if the said question is considered by a court having jurisdiction to consider an appeal under Section 21 of the said act. And since an appeal under 21 of the National Investigation Agency Act lies before Division Bench of the High Court, the registry is directed to lay this matter before Honorable the Chief Justice for appropriate order in terms of Section 21, Clause 2 of the National Investigation Agency.
Milord, item number 24, we have entered appearance today, Milord. May I pray, Milord, I have informed the other side also, because it's a money decree. So therefore, we'll also like to place our case on 16th, Milord. Next week, actually, there is some marriage in the family, so.
Yeah.
No objection, Lord. NCR was called, my lord, on 12/8/25. That has also not been received till date. My lord. That may be directed, my lord.
Heard Mr. H. Gupta, learned counsel for the appellant. Also heard Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. R.J. Das, who submits that he has entered appearance for the respondent today only. And therefore prays that the matter may be listed
On 16th, Milord.
on 16th of January,
No, Milord, in December.
16th of December. Mr. H. Gupta, learned counsel for the appellant, raises no objection to the said prayer. it also appears that the records, whether there was a Order.
12/8/25.
order was there,
Yes,
it
12/8/25.
also appears that the records of the trial court have also not been received. Hence, the registry is directed to issue reminder for the same, list accordingly.
My lord, my objection part, my lord, may not be there because my lord, there is an execution going on 9th, my lord, that may not be recorded, my lord, because let it, my lord, they are taking time, my lord.
Okay. Learned counsel raises no objection line to Karthik.
Deep Lord.
Obligation.
Made please for your lordship. Lordship, with the consent of the amicus curiae, I beg to mention item number 10 of today's daily list, lordship. Lordship, my senior Mr. M.K. Das, his relative expired yesterday, so I need an accommodation for the day, lordship. Item 10.
Heard Miss
MS B. Chetri on behalf of Mr. M.K. Das.
B. Chetri, learned B.
B. Chetri.
B. Chetri, learned counsel for the petitioner, who prays for an adjournment on the ground that the engaged counsel for the petitioner is in bereavement. She submits that she has informed about her prayer for adjournment to the learned amicus curiae as well as learned additional public prosecutor. The prayer is allowed.
Lordship, we
Where?
fix on 10, lordship. 10th of December.
Lordship, the last date was 1/11/25 before the trial court, Lordship, it was fixed for consideration of charge. The records are not updated.
Lordship, now on 8/11, it's fixed for the examination of the mother. On 2012, it has been fixed for the examination of the informant as well as the victim, lordship. Lordship, may fix on 10th, lordship.
After 2012,
Lordship, please kindly accommodate me on 10th, lordship. 10th of December, lordship.
it is a POXO matter.
Lordship.
Then the examination of victim is, it is a bail matter, unlikely that you will get bail on 10.
File an affidavit putting on it, record some facts, lordship. Lordship, may kindly accommodate me on 10th, lordship.
Okay, on 10. Let it be on 10.
Obliged, lordship.
May I please, Your Lordship, I beg to mention for item number 25, Your Lordship. We have entered our appearance today. 2 weeks' time may be given for filing our affidavit in reply, Your Lordship.
You have informed the other side.
Yes, he's here. I am for the respondent, Your Lordship.
Lordship, interview may be continued.
Heard, Mr. What is your name?
C. Talukdar.
C. Talukdar, learned counsel for the petitioner. Also heard Mr. U. K. Burman, learned counsel for the respondent, who submits that he has entered his appearance in this case today only and needs some time to file objection
Affidavit in reply, Your Lordship.
and affidavit in reply. The prayer is not objected to by the learned counsel for the petitioner, hence same is allowed. Let this matter be listed
After 2 weeks' time.
after 2 weeks on a date to be fixed by registry. The interim order granted earlier shall continue till next day.
Obliged.
May I please, to the Lordship. Lordship for listing a member matter, orders Bloom, service has been completed, my lord.
Listing,
Service has
senior
been-
court is there. Listing, you have to go before senior court. All listing prayers should be made before senior court.
Yes.
It please, your lordship, with the consent of the other side, I beg to mention item number 26, your lordship. We are yet to file our affidavit in reply.
So you need time.
Yes, lordship, for 3 weeks, your lordship.
You have informed the other side.
So I am for the respondent, Your Lordship. And Your Lordship, maybe a date may be fixed. Any day after vacation.
There is an interim.
Heard Ms. K. Sharma, learned counsel for the petitioner. Also heard Mr.
Our Paul.
R.
Yeah, yeah.
Paul, learned counsel for the respondent. Learned counsel for the petitioner seeks some time to file an affidavit in reply against the objection filed by the respondent in this case. The counsel for the respondent does not raise any objection. Hence the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry. The interim order shall continue till next day.
Maybe the lordship, lordship, I beg to mention Back to mention item number 19, my lord. Maybe exam for the day. Difficulty on the part of the document.
You have informed
My lordship, this other side is not there.
heard Mr. R.
Chaudhary.
R. A. Chaudhary, who prays for an adjournment on the ground of
Difficulty on the part of the conducting council.
difficulty on the part of the conducting council for the applicant. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Highly appreciated.
Daily list, would be item number 4.
May it please lordship. Lordship, this is NDPS matter commercial contract. Today was fixed for CD lordship.
Is there is there heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Ms. M. Deka, learned counsel for NCB, who prays for some,
Today is the first day, Lordship.
okay,
No Thursday. No, today was fixed to bill hearing, but it has come in the more from column.
who prays for, case diary was called for earlier, who prays for some more time for production of the case diary. When
Next week.
the prayer is allowed. Let this matter be listed. Why this case has come before this court?
Earlier it was withdrawn lordship.
Let this matter be listed on 17th of December.
Highly obliged.
Obliged.
Item 5.
May I please, your lordship? Your lordship, 483 bail application, lordship, allegation is under section lordship 65 to BNS and the section 6 POCSO Act lordship. Your lordship.
Notice,
And your lordship, 3 witnesses were examined, lordship, and petitioner is lordship behind the bar since lordship 25 to 2025, lordship, and your lordship, today's lordship, he has a completed lordship 285 days, lordship. And
why the prayer victim has been examined?
Victim also examined, father also examined, and the school headmaster, lordship, he also examined, lordship, because incident occurred, lordship, at the
Okay,
school,
we'll issue notice to
Yes,
victim. Heard Miss
MRDV.
M.R. Devi, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Issue notice to the respondent number 2 in pursuant to the prevailing notification of the registry of this court in this regard. The petitioner shall take steps for issuance of notice upon the respondent number 2 within 3 days from the date of this order, returnable on 6th of January. 6th of January. Let also the scanned copy of the trial court records along with the scanned copy of the connected case diary be called for list accordingly.
Okay.
Item 6.
May it please your lordship. Lordship, have been arrested under section 18B of the NDPS Act on the Your lordship, the charges leveled against me is that I have been cultivating opium.
It is a charge sheeted case.
Charge sheet has been, yes, your lordship.
18B is
PM commercial.
commercial.
But your lordship, I was not arrested from the site and no recovery had been made from me. And I was arrested on the basis of 2 witnesses who were present at the site.
No, what is your ground?
Your lordship, the foremost ground is that your lordship, I was no recovery was made from me. And I was
Then
arrested
records
from
would be necessary. Heard
GR Datta.
Mr. G.R. Datta, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Perusal of the scanned copy of the trial court records along with the connected case diary would be necessary for consideration of the instant bail application. Hence call for the same. Let this matter be listed. 9th of January.
DPO.
Item 7,
POCSO case can put in it also. Notice and
POCSO case.
Also,
Trial is going on, Lordship. Already 6 witnesses have been examined. Can a date be given before the vacation, Lordship? It's the second time the bail application has been filed. The victim, informant, all have been examined. Only the official witnesses are left. Can it be on 17th, Lordship, of December?
no notice has to go.
Notice has to go. 2 weeks, Lordship. 17th.
Heard Mr. V. A. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Issue notice to the respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on 17th of December. Let also the scanned copy of the trial court records along with the connected case diary be called for. Registry to take steps for requisitioning the aforesaid scanned copy. List accordingly.
DPO.
item 8,
May I please your lordship, this is anticipatory bail application, my lord, this is third occasion. But my lord, we have approached before this honorable court with 3 very new and very important grounds, my lord. And before going to the grounds, my lord, may I place the gist of the affair, my lord? Very long affair, my lord.
Third occasion.
My lord,
Where are the earlier rejection order?
my lord,
Page 162 is the second rejection order.
my lord,
160.
161, my lord, relevant person.
Relevant is 162.
It was rejected, my lord, because there was material in case diary and no new grounds were there, my lord.
What is your new ground?
My lord, in page number 7, my lord, in para number 7, 8 and 9, my lord. May I read, my lord?
Yes.
Para number 7, my lord, the petitioner begged to state that another FIR name accused person, namely Kiran Das, who was the then branch manager of Central Bank of India, Dhamdama branch, district Baksa, Assam, is allowed to go on pre-arrest bail by this honorable court, dated 1/5/2025, passed in BA number so and so so and so. And my lord, in this bail application, it is mentioned that though the earlier allegation was that the anomalies was to the tune of rupees 3,20 lakhs and some thousand, but my lord, in this order, my lord, in kindly see, my lord, in page number 36, my lord. Page number 36, my lord, kindly see. In the departmental inquiry, my lord, in the memorandum of allegation, my lord, it was stated that allegation was only to the tune of 25 lakhs. And on that ground, my lord, honorable court give the privilege of pre-arrest bail, my lord, to the accused person in, my lord, page number relevant part, page number 38, para number 8, my lord. This para number 8 and 9, my lord, submission of
That
the
is
learned
to a
counsel.
different accused person. Some
My
other.
lord, branch manager, and I was the driver of that branch manager, my lord. And other accused person is my wife, my lord. She runs a CSC center, my lord, on that under that branch, my lord. And this accused person is, my lord, branch manager of that relevant period, in the tenure of which, my lord, whole allegation, whole corruption was, my lord. My lord, kindly see, my lord, para number 18, my lord, in page number 40, my lord. Kindly see, my lord. May I read, my lord? However, considering the submissions made by the learned senior counsel for the petitioner as well as the documents produced before this court, that is the article of charges issued to the petitioner in connection with the disciplinary proceeding initiated against him, with regard
No,
to the
no, what
same-
is your ground?
My lord,
So the
has
branch
my-
manager was granted bail.
That is one of ground. Second, my lord, his ground of giving bail was that though allegation was initially to the tune of rupees 3 crore and something, actually the anomalies were only for 25 lakhs, number two. And number three, my lord,
But still that 25 lakhs is there.
and my lord, on that ground, my lord, he was given bail. And third, my lord, though it was said that in my accounts, my lord, number of illegal transaction was done. I have, though I am my liberty was curtailed, my lord, I cannot collect all the bank statement, my lord. I have annexed a lot of banks account in which it is clear that there is no, my lord, credit more than 1 lakhs, my lord. And I am, my wife is, my lord, running a CSC center under the bank, my lord. My husband, the petitioner number one, he is the driver of that branch manager, my lord. Making me scapegoat, my lord. All that corruption was going on, my lord, in that branch during
No,
the tenure
but
of that,
these submissions were considered earlier also.
my lord. I am a scapegoat. That submission was considered, but he's giving bail, the giving bail of branch manager. And my lord, my accounts details was not considered earlier, my lord. And that ground, that earlier allegation was, my lord, 3 crores. Thereafter allegations comes to be, my lord, 25 lakhs. That was also not considered in my bail application, my lord.
Lordship, here I'm just clarifying one thing, Lordship. The first two grounds which he has taken, Lordship, in relation to the other co-accused who was granted interim protection, Lordship, that was, Lordship, not only because of the amount. It was because, Lordship, he had shown, Lordship, that on the date of occurrence, he was posted at a different place. That is at paragraph 11, Lordship, at page 39. Upon this ground, Lordship had granted him anticipatory bail. Paragraph 11, Lordship, page 39. So, Lordship, that submission is not tenable. It was not because of the difference of amount, Lordship. Amount may be whatever, Lordship. And regarding the third ground, Lordship, this was also urged in the earlier two bail application.
Okay. My lord, this corruption was found out after his transfer, my lord. But the corruption was during his tenure from the year 2021 to 2024. But when he was transferred to the Nalbari branch, my lord, a new branch manager come to the concert branch of Thamram, then, my lord, these anomalies were found out, my lord. On the date of occurrence,
What is the status of investigation?
Lordship, I have to inquire, Lordship.
my lord, one thing may be kindly considered. After his transfer to the Nalbari branch, new branch manager come to Dhamdama branch. Then, my lord, anomalies were found out, my lord. Therefore, on the
Okay.
date of FIR, my lord, he was.
We'll call for case diary.
My lord, one thing, my lord, kindly see, my lord. Para number 20, my lord. Para number 20, my lord, in page number 41. It also appears that though the petitioner was not under any protection till date, however, he was not arrested by the investigating officer till date, which also shows that either the police has been unable to arrest the petitioner or either deemed it necessary to arrest him. My lord, this order was in the month of May, my lord, 2025. Now it is, my lord, December, my lord.
Okay, we'll find out.
Lordship, all what
Um,
case.
And my lord, the petitioner number 2, my lord, she is a woman, my lord. She has a 3 years old minor baby, my lord.
No, this
Her
is no
condition
interim.
may be considered,
No.
my lord.
We'll consider both cases,
My lord,
but let the case
the
diary
bank
come.
manager, the cashier, they are given bail, my lord. And how my lord, detention may be required, my lord. The main accused person, the bank manager, he was given on bail, my lord.
Let us peruse the case diary.
And my lord,
We'll-
one thing is required, taking advantage of my absence, my lord. The actual fact of the case was not placed before the IML. My lord, at least give me a chance to record my statement, my lord. Actually, there was no misappropriation, my lord. There was a money lending business, my lord. Taking advantage of my absence, my lord. All these are not placed before the IU, my lord. This is a money lending business, my lord, from the case of the bank, my lord. My lord, give me a chance to record my statement before the police, my lord. Kindly, my lord. Only my humble submission is that only in that case, my lord, the case will take its proper course, my lord.
We will go through the case diary thereafter. If you are entitled to relief, you will get it.
My lord.
Otherwise not.
There are, my lord, there are
Heard
materials
Mr.
against me,
R.
my lord.
Sharma, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of BNSS has been made by the petitioners, namely Pulen Burman and Srimati Jumi Burman, who are apprehending their arrest in connection with BIO within bracket EO police station case number 6/2024. Stop. Since this is for the third time the petitioners have approached this court after their earlier two bail application being rejected, comma, this court intends to peruse the case diary before passing any orders in this case. Hence, call for the case diary. Let this case be listed when? 19th of December.
So
The
19.
issue of maintainability may be kept open, Lordship. New grounds. Lordship.
Yes. You have to satisfy
Lordship.
that third anticipatory bail application is maintainable and the grounds taken by you are new grounds. That satisfied, you have to satisfy that on the next day after arrival of the case.
It can be reflected in the order. Otherwise it will be
My lord, the bail order of the branch manager is new ground, my lord. This is a parent, my lord.
The learned additional public prosecutor has submitted that this anticipatory bail application is not maintainable as no new ground has been pleaded after rejection of the bail application of the petitioner on two earlier occasions. Stop. Eto uporat dibo, list accordingly on in 19.
Obliged, my.
Court application, item 9.
Lordship, my senior is on legs, Lordship. Matter may, Lordship, my password on for time being.
We'll admit it. This is. Okay. Who is for the other side?
Lordship, no steps have been taken till now, Lordship.
What is this?
Lordship, this FAO is against injunction order passed by the learned trial court, Lordship. Civil judge at Amingao, Lordship.
Okay, we'll take it up after some time. Who is your senior?
RK Bhuya, Lordship.
Okay, we'll take it up after some.
Court hearing under order 41, item 11.
Yes, legal lordship.
Video. Video. Yes.
I take it to President and order dated 20/12/2024. What happened, my lord? Earlier, one suit was filed by Bonomali Station Road, Jama Masjid, which is a title suit number.
Yes.
One earlier suit was filed, one Bonomali Jama Masjid, which was now is in execution proceeding. And now the suit was expertise and now the appellant has filed this suit and this is dismissed by the appellate court and trial court also. The ground taken is that page number 5, your lordship. The judgment and decree dated 37 to
No, what is the substantial question of law?
Substantial question of law, my lord, page number 6. Substantial question of law arises whether trial court as well as appellate court has jurisdiction to decide the dispute of mosque property which was filed by Karimganj Bonomali Station Road Jama Masjid, represented by its Matwali Abdul Noor being title suit number 2011-2001 before the learned trial court and the learned trial court expertise decree 137/2003. And connected TX 8 of 2005 was also pending before the execution court Munsif 1 Karimganj. Since according to the provision of section 85 of the Waqif Act 1995, civil court has no jurisdiction to
entertains suit or legal proceeding related to work property, and the same is required to be determined by the Waqf board under the act. Number 2, substantial question of law
What
arises.
is section 85?
85 section, please.
The
Waqf property,
property is a work property.
Your Lordship.
Whether this plea was taken before the trial court.
No, Your Lordship, but they have admitted their written statement that they have the Waqf property, and in his cross he has admitted, Masjid Mola, that he know that there is a Waqf property and the suit being treated in the Waqf property. But knowing the same, he is filing the suit before the trial court, and the same was decreed expertise, and now the same is on execution proceeding.
Read 85.
85, Your Lordship. 85, section 85, bar or jurisdiction of civil court. No suit or other legal proceeding
Work of
shall lie in any civil court, revenue court, and any other authority in respect of any dispute, question, or other matter relating to any Waqf property or other matter which is required by or under this act to be determined by the tribunal.
Now, how this is a substantial question of law?
Normally, Masjid property previously filed one suit which was ex parte, and the same was now in execution proceeding. And now the plaintiff was one of the defendant, but the suit was ex parte. That's why these plaintiffs filed the suit, and they are taken the question that the suit was taken fraudulently and collusively. That's why this substantial question of law, I added. In his written statement or cross, he has admitted that this is a masjid property, and he know that the same was entered before the Waqf board. Knowing the same, but he has filed the suit before this Honorable Civil Judge Karimganj.
What is your name?
B. Sarkar.
Heard Miss B. Sarkar, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure 1908 has been filed by the appellant. You were the plaintiff.
Yes, Your Lordship.
You filed the suit for
My little portion is occupied by the Jama Masjid. That's why I am affected. Previously, title suit filed by the Jama Masjid, and the same was now in execution proceeding. Now I am filed the suit, but my suit was dismissed.
your suit was dismissed. Thereafter, you prefer an appeal.
Yes, Your Lordship. But nowhere the ground is taken. But their written statement, they have already admitted. They have the masjid property, and in her cross, the masjid property is taken by the Waqf board. That's why I have taken this ground.
No, you have taken ground that the suit is not maintainable because of 85, section 85.
85?
But suit is your suit.
No, the suit was filed prior the Jama Masjid, and the suit was ex parte decree. Now the suit was challenged by me. By of title suit number 12605, thereafter title appeal number 17 of 19.
Who was the plaintiff in that suit?
That suit, the defendant number 7, but he is not, I have not party, but one defendant number 7 has party, made party.
No, facts are not clear. You filed title suit number 126.
Yes, your lordship. May I read the title suit, your lordship?
And the suit was dismissed. Why it was dismissed?
Little portion, and the suit was dismissed due to DAG number. They said that DAG number is 455. Judgment, your lordship. Title appeal judgment 55.
No, why your suit was dismissed?
So 54. Defendant number 1, Karimganj, Bonamali, page number 54. Bonamali, Karimganj Station Road, Jama Masjid, represented by Abdul Noor, the Matawali of defendant number 1, Abdul Noor, defendant number adduced his evidence and pleaded that the suit land of title suit number 2011-2001 is covered by DAG number 4559 of Khatian number so and so. DW1 stated that the plaintiff land is covered by DAG number 5558.
Who are you? Parimal Chakravarti.
Yes, your lordship.
You are Parimal Chakravarti.
Yes. Porimal Chakraborty and others. On the date of Porimal Chakraborty, the legal here substituted. Previously.
You are not able to properly explain. We'll take it up tomorrow. I'll go through the records. I have not gone through the records.
Okay, highly
We'll take it up on Monday,
next Monday.
next Monday.
Highly applied.
Heard, Miss.
You only issue notice.
No, for issuing, no, we may dismiss it also if you don't have a case.
Up to you.
They-
Up to you.
What is your name?
B. Sarkar.
Heard, Miss B. Sarkar, learned counsel for the appellant. Let this matter be listed next week at the date. Listed on 10th of December. Again.
Item 9.
Itu lunch of more chamber of the people. Yes.
Within appeal against order, your lordship, that order has been passed, granting order of status quo against me. So, lordship, I am the defendant in the original suit.
Will issue notice. Heard Mr. R.K. Bhuya, learned counsel for the appellant. This appeal under order 43 rule 1 within bracket R of CPC 2008 has been preferred by the appellants, impugning the order dated 5/11/2020 passed by the Court of Learned Civil Judge Senior Division Kamrup at Amingaon in Misje case number 20/2016 arising out of title suit number 19/2016, whereby on a prayer made by the respondents, the order of status quo in respect of the suit property was granted. Stop. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
I is there, but it will be moved after the appeals.
Let them appear first.
Yes.
Order item 12.
May it please your lordship. Your lordship, in this case, service is completed upon the respondents and LCR has been received, your lordship.
Heard Ms. P. Bhakur, learned counsel for the appellant. Also heard Mr. S. Datta,
Respondent 1, 2, 3, and 4.
learned counsel for respondent number 1, 2, 3, and 4. It appears from record that the notice issued to respondent number 5 and respondent number 6 has been duly served, and the records from the concerned motor accident tribunal have also been received. Hence, this case is ready for hearing. List it accordingly up for hearing after 4 weeks.
Obliged.
13.
May I please your lordship? My lord, this petition has arisen against the impugned order in judgment dated 15th July 2022, passed in miscellaneous appeal number 7 of 2022 by the learned civil judge Hailakandi, allowing the appeal
Why it has come up for orders column today?
because we have already completed completed to take the steps, and today is for call lower court record. So the matter may kindly be.
Service is complete.
Sir, I'm
Oh.
appealing on behalf of respondent number 1 and 6 on
Okay.
behalf of Mr.
Trial court records have been received. No. Heard Miss, what is your name?
Pompa Chaudhary.
M. Chaudhary, learned counsel for the petitioner. Also heard Miss N. A. Laskar appearing for
6.
respondent number 1 to 6. It appears from record that the trial court, it appears from office note dated 2/12/2025 that the trial court records which were called for in connection with this case have not yet been received. Issue reminder for the same. List this matter after receipt of the trial court records.
Highly obliged.
14.
May I please,
Yes.
Lordship, we have come to know that the addressee has moved to another place. So something.
Addressee means respondent number.
2, Lordship.
I am suffering, lordship. I am for the claimant, lordship. They have not completed the steps. Nothing has been paid.
Stay is there.
Yes, lordship. Entire judgment has been paid without depositing.
You have not deposited anything.
Lordship,
Claimant is a permanent condition.
You pray for vacation of stay.
Yes, lordship. I have to file.
You file an application, we will vacate
And
this.
again, step we have to take in steps upon all the responsibility. That is difficulty is there.
By which order stay was granted?
They was granted. lordship. Three 6/2022. lordship.
36.
36.
A separate miss case was,
Miscase 1884,
that has been disposed of.
not this one. It is pending.
We'll vacate this stay.
So Thought that maybe. then the process.
or you deposit
Deposit at least 50%.
50% deposit. We'll give one chance. In stay application also,
Give me one second.
because stay is only till
Till returnable date.
returnable date. And the IA has not been disposed of.
Disposable.
While disposing of, we'll pass some order.
Short date may be fixed.
Okay, heard, Mr. What is your name?
As per your-
S. Pegu, Learned Counsel for the appellant. Also heard Mr. S. Dutta, S. Deka, Learned Counsel for the
Respondent number 1.
respondent number 1, as well as K. Bhatto, appearing for respondent number 3. Learned Counsel for the E2 IARO MSc Dutta the हूँ, common order. Learned Counsel for the appellant has submitted that the petitioner could not take steps for issuance of notice upon respondent number 2, as it has been informed that respondent number 2 has moved out from his earlier address, and new address, and the appellant/applicant is yet to find out the new address. So, he therefore prays for some time to find out the new address of the respondent number 2 and take steps for issuance of notice upon the respondent number 2. Stop. It appears from record that the impugn order has been stayed, has already been stayed by order dated 30/6/2022, passed in IA Civil number 1884/2022, and the appellant/applicant is yet to take steps for effecting service on respondent number 2 in his given address. Under such circumstances, the stay granted on the impugn judgment and award by order dated 30/6/2022 is liable to be vacated, however, one chance is hereby granted to the petitioner, to the appellant, to take fresh steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode, after ascertaining the proper address of the said respondent within 7 days from the date of this order, returnable on the date at the
January.
returnable on 8th January.
On that I will be considered.
Yes,
Like,
list accordingly.
May it please your lordship. Your lordship may peruse office note dated 29/11/2025. Respondent number 1 and 2 has filed your wakalatnama, and as regards respondent number 3, notice is received by Sathi Roy. That is respondent number 2, your lordship, is the owner. They are from the same place, your lordship.
Who is Sathi Roy?
She is the owner, respondent number 2, your lordship.
How he is related to respondent number 2?
They are Respondent number 3 is the driver and respondent number 2 is the owner, Your Lordship.
But they are not related.
Otherwise, Your Lordship, appeal is purely on quantum. Respondent number 3 is the driver, Your Lordship. Same may be struck off.
Okay. Heard Ms. P. Bhattakur. No one has appeared for 1 and 2.
File your wakalatnama, Your Lordship.
Heard Ms. P. Bhattakur, learned counsel for the appellant. It appears from the office note dated 29/11/2025 that notice is issued to respondent number 1 and 2. No, sorry, that notice is issued to respondent number 3 has been served by effecting this has been served on one Sathi Roy, that is respondent number 2, who was the owner of the vehicle and who had engaged the respondent number 3 to drive the said vehicle. It also appears that respondent number 1 and 2, that it also appears that the engaged counsel for respondent number 1 and 2 have filed wakalatnama, or in this case on their behalf. In view of above, the notices issued to respondents are held to be duly served. The records of the concerned motor accident claims have not yet been received. Hence, issue a reminder for the same. Registry to issue reminder. Release this matter after 4 weeks on receipt of the trial court records.
Your Lordship, may peruse office note dated 29/11/2025. Respondent number 1 has filed his wakalatnama. As regards respondent number 2, notice is duly served, Your Lordship. But as regards respondent number 3, it has been stated that he was out for work and he told that he has already received the notice by post. And as such, he has refused to accept the notice, Your Lordship.
You are appearing for?
Respondent number 1, Your Lordship.
Heard Ms. P. Bhattakur, learned counsel for the appellant. Also heard Mr.
A. Mishra on behalf of S. Navas.
A. Mishra, appearing for respondent number 1. On perusal of the office note dated 29/11/2025, it appears that notice issued to respondent number 2 has been duly served on him by the process server, as well as notice issued to respondent number 3 has been refused to be accepted by the respondent number 3 on the plea that he has already received notice through post. In view of the office note and after going through the report of the process server, the notices issued to respondent number 2 and 3 are held to be duly served. It also appears that the records from the concerned motor accident claims tribunal have already been received. Hence, this case is ready for hearing. Release this matter for hearing after 4 weeks.
A fixed date in January, Your Lordship.
No fixed date. After 4 weeks on a date to be fixed by registry.
Obliged, Your Lordship. 17.
Lordship, may peruse office note dated 29/11/2025. Respondent number 1 has filed their wakalatnama. As regards respondent number 2, notice is received by the mother, and respondent number 3 duly served, Your Lordship.
Mr. Agarwala, you are appearing for?
Responding to one claimant.
Heard Ms. P. Bhattakur, learned counsel for the appellant. Also heard Mr. A.R. Agarwala, appearing for respondent number 1. On perusal of the office note dated 29/11/2025, it appears that notice issued to respondent number 2 and 3 have been duly served.
LCR also received.
LCR has been received, Your Lordship.
The records of the concerned motor accident claims tribunal have also been received. Hence, this case is ready, this appeal is ready for hearing, listed for hearing after 4 weeks on a date to be fixed by the judge.
If that, if possible.
Not possible.
Okay.
Please, Lordship. Lordship, my senior is busy in another court. Kindly pass over the matter for the time.
My lord, as per the last order, LCR was called for, but it has not yet been received. Let a reminder book. Because LCR will be needed.
What is your name?
He does.
Heard Ms. P. Das, learned counsel for the appellant. Also heard Mr. D.K. Bhattacharya, appearing for
Sole respondent.
sole respondent. On perusal of the office note dated 13/6/2020, dated 1/12/2025, it appears that the trial court records have not yet been received. Issue reminder for the same. Registry to issue the reminder
Civil Judge 2 Senior Division.
for the trial court for the aforesaid records to the Court of Learned Civil Judge,
2 Senior Division.
Senior
Kamrup Metro.
Division number 2, Kamrup Metro. List this matter after
Receipt of
receipt of the trial court records.
obliged.
20.
May it please your lordship. Lordship, kindly peruse the order dated 2024.
Order dated
28/203/2024, lordships.
in which case?
IA 783/2024. I have filed to release the award, my lord. To withdraw the 50%, my lord. Against that, they have filed an objection, my lord. But whereas that objection is not maintainable because the opposite party has no objection at that time. That is my case. They were appeared
Which order you are referring to? Order dated
28/3/2024.
passed in IA number
IA number 783/2024.
783. So 783, there is no IA.
But it's 789 of 2020, that is the stay application.
789.
The stay was granted subject to 50% of the deposit which we deposited and to which they have filed an IA, which is IA 2887 of 2024 for withdrawal. Your Lordship, earlier we had filed an objection, but it was not on record. It was also called by the registry.
Oh, I'm sorry, my lord, that order is.
So your Lordship, we have filed an objection yesterday once again. So that objection
This
is
IA is for
IA
To
2887.
withdraw the, yes, my lord. 2887, no? Yes, yes.
2887 of 24. It's a withdrawal application filed by the claimants.
And order has been passed. To withdraw the amount, my lord.
what is 3678?
Your Lordship, 367, it is condonation and filing substitution petition. Respondent number 3, who is the owner of the alleged offending vehicle, he has expired, Your Lordship. So we have filed substitution petition, and as per the office note dated 27/11/2025, the legal representatives have filed their wakalatnama, Your Lordship. So the substitution petition may be condoned and substitution may be allowed to proceed, Your Lordship.
We'll take one by one.
Should we first take the condonation in filing substitution, IA 3678.
3678. Yes.
Yes, Your Lordship, in this petition, we have prayed for substituting respondent number 3. Respondent number 3 is an necessary party. He is the owner of the vehicle, Your Lordship, and our ground of appeal is infraction of the policy condition. So it is important that respondent number 3 is substituted. There has been a delay
You
of
have any objection? Ms. Devi, you have any objection regarding substitution? Condonation of
They have already appeared, no?
They have appeared.
They
They
have
filed
appeared.
wakalatnama. The legal representatives, 3A and 3B, they have filed
but
wakalatnama.
this prayer has not yet been allowed.
In spite of that, they have appeared earlier before passing
Yes.
this order.
Yes, Your
So
Lordship.
sad, my lord. So I got shocked. Without having noticed how legal is.
Heard Miss K.
A-
B.
A. Biani.
A. Biani, learned counsel for the applicant. Also heard Miss also heard Miss K. Devi, learned counsel for
Appearing on behalf of respondent number
respondent number 1 and 2.
when my lord,
Layman.
Madam. Not by owner.
This application under section 5 of the Limitation Act 1963 has been filed by the applicant insurance company, praying for condoning the delay of 774 days in filing the application for setting aside of abatement and substitution of the legal heirs of the deceased respondent number 3, who was the owner of the offending vehicle. Learned counsel for the petitioner has submitted that at the time of effecting the notices issued to respondent number 3, namely Icha Haq Ahmed by Dusty Mode, the present applicant came to know that the said respondent has already expired on 28/5/2021. Stop. She submits that since the respondent number 3 is the owner of the offending vehicle, and since one of the ground in this appeal preferred by the present applicant is infraction of policy conditions, hence respondent number 3 is necessary party. She submits that where are the causes for delay?
It has been explained in paragraph 3, 5 and 6, Your Lordship.
She submits that cause for the reasons for approaching this court beyond the prescribed period of limitation for setting aside abatement as well as substitution of the legal representative of respondent number 3 has been mentioned in paragraph number 3, 5 and 6 of the instant condonation of delay application. Hence, she submits that the delay, hence she submit no. Cut the J line. She submits that the causes mentioned, the grounds mentioned in the aforesaid paragraphs are sufficient grounds, are sufficient cause which prevented the present applicant in approaching this court by filing the application for setting aside of abatement and substitution within the prescribed period of limitation. Stop. On the other hand, learned counsel for the respondent number 1 and 2 submits that considering the grounds shown by the applicant in her delay condonation application, she has no objection if the delay is condoned. Stop. Considering the submissions made by learned counsel for the parties, as well as considering the grounds shown in paragraph number 5, 6, 3, 5, and 6 of the delay condonation application to be sufficient ground which prevented the present applicant from approaching this court within prescribed period of limitation, comma, the delay of 774 days in preparing the application for setting aside of abatement and substitution is hereby condoned, and this interlocutory application is accordingly allowed. Next, where is the abatement?
3680.
3680. Third miss ABN party नाम एक ही रखना. This application has been filed. This interlocutory application has been filed by the applicants / insurance company for setting aside abatement of the appeal against respondent number 3 on his death. On his death on when he died, on his death on 28/5/2021. Stop. Learned counsel for the petitioner applicant has submitted that the present that the appeal against respondent number 3 got abated by operation of law as the applicant were prevented by sufficient cause from preferring the from filing the application for substituting the legal heirs of respondent number 2 within due time. Respondent number 3 within due time. She submits that the delay in preferring the instant application for setting aside abatement has already been condoned in IA number
3678.
3678
2024.
of 2024. The learned counsel for the respondent claimant has not objected to the prayer for setting aside of the abatement. Moreover, for the reasons stated in paragraph number 6 of this instant interlocutory application, this court is of considered opinion that the applicant were prevented by sufficient cause in preferring the substitution applications within the period prescribed period of limitation. Hence, the abatement of the appeal against respondent number 3 on his death is hereby set aside, and this interlocutory application is allowed. Substitution petition application.
IA 3679.
Parties are eligible. This interlocutory application has been filed by the applicant insurance company under Order 22 Rule 4 of the CPC for substitution of the legal heirs
Respondent number 3.
of respondent number 3, late Icha Haq Ahmad on his death. Learned counsel for the petitioner has submitted that the abatement of appeal on the death of respondent number 3 against him has already been set aside by this court in IA number
3680.
3680 of 2024. She also submits that delay in preferring the instant substitution application has also been condoned by this court in IA number
678 of 2020.
3678/2024. She submits that since Icha Haq Ahmed was the owner of the offending vehicle, hence he is a necessary party in this appeal, and prays for substituting the legal heirs, namely Srimati Ajiza Khatun Ahmed and Mr. Arif Ahmed, as the substituted respondent in this case. The prayer is not opposed to by learned counsel for respondent number 1 and 2. So for the ground stated in the application, the prayer is allowed. The name of Srimati Ajiza Khatun Ahmed and Mr. Arif Ahmed be substituted respectively as defendant respondent number 3 within bracket A and respondent number 3 within bracket B in place of deceased respondent Icha Haq Ahmed. You will file the
First.
applicant / appellant is directed to file amended cause title within a week from the date of this order. This interlocutory application is accordingly disposed of. Now, move.
Now, IA 2887.
My lord, I have filed IA, my lord, 2887 2024, my
Yes,
lord, to withdraw the 50% award, my lord. But they have filed objection against that IA.
Where is the objection?
Should the objection was earlier filed, but it was not on record, so we have filed it yesterday once again. So Lordship, this may be taken up next week along with the
Earlier
objection.
also, they have stated that they have taken so many times. Lordship, can you peruse the
Yes, Your
date,
Lordship.
my lord? They have taken so many times
Lord-
that they have filed
Okay,
objection.
now
but
they have
did not
already
file.
filed.
I have not received objection, my lord, before
Your
that.
Lordship,
In spite of that, they have submitted that they have filed objection, then I have entered the matter, then I have come to know that
Your Lordship, we
they
had
have filed
earlier-
yesterday only. That is, I received
we have,
3:10 PM, my lord, yesterday.
Your Lordship, earlier also we had filed, but
That may
inadvertently
be
it was.
fixed for hearing, my lord, for the award, my lord. Next week.
Heard Miss K. Devi, learned counsel, and this is 2887, IA number 2887. K. Devi, learned counsel for the applicant. Also heard Miss A. Biani, learned counsel for the respondent / insurance company. this interlocutory application has been filed by the respondent by the applicants slash claimant praying for a direction for disbursing the 50% of the awarded amount which has been deposited by the insurance company in pursuant to the order dated 6/1/2021 passed in IA Civil number 789/2020 in connection with MSc Appeal number 131/2020 as a condition for grant of stay of the impugned order. Learned counsel for the opposite party slash insurance company submits that the insurance company has filed an objection to the present interlocutory application yesterday only, and the said objection is not on record, and therefore she prays for directing the registry to place the objection on record and fix this matter for hearing in the next week. Stop.
Let me fix.
The prayer is
And-
allowed. The applicant is directed to furnish a copy of the objection.
Yesterday I received at about 3 PM, 3:10 PM.
The registry is directed to list this matter.
11
List this matter along with the objection filed by the insurance company on when
11, my lord.
11.
For hearing, if it is fixed, it may be fixed after the vacation, your lordship.
No, only this.
The objection.
Already objection, my lord. Next week, my lord.
Yes, sir, for
She
objection.
wants 1 week, now she
No,
said that.
just-
Your lordship, if it is just objection, it can be fixed anytime next week. I was just talking about the hearing, your lordship.
No, I'm not mentioning about hearing. Next week, my lord, hearing about the
11th is fine,
objection.
your lordship.
Whether case is ready
The
for
poor
hearing.
They did not get money, my lord, the wife and the mother, my lord. Now, why they have filed
It's ready
objection?
for hearing, your lordship. LCR has also been received.
Twelfth. On 12th of December. On
Lordship,
12th,
objection petition.
or
Yes.
for hearing of this interlocutory application number 2887.
Oblige.
Item 21.
Wait, please, your lordship, my lord. Plaintiff is the respondent, my lord. File this IA for my lord, early hearing.
I for
Early hearing, my lord.
any objection? When?
He date in the month of February, my lord, first week.
After due purpose.
Okay. Heard Mr. What is your name?
HP Gwala, my lord.
HP Gwala, learned counsel for the applicant. Also heard Miss
A. Burman.
A. Burman, learned counsel for how many respondents are there?
11.
All respondents. Learned counsel for the respondents. This application, this interlocutory application has been preferred by the applicant. You are the appellant
My lord, I am the plaintiff respondent, my lord.
in the appeal.
Appeal.
We are appealing in RS.
is the-
Uh, applicant respondent in connection with RSA number 7/2021, praying for an expeditious hearing of the connected regular first appeal, as the matter has. Why you need expeditious hearing?
Because, my lord, the concurrent finding in favor of us, my lord. Plaintiff, my lord. And my lord, the
On the last line. can you- as the matter pertains to the year 2021. Stop. Ms. A. Burman, learned counsel for the respondent, does not oppose the prayer for early hearing. Accordingly, considering the whole pendency of the connected regular second appeal, this interlocutory application is allowed, and the registry is directed to list the regular second appeal number 7/2021 for hearing as a fixed item on
5/2/20.
6th of February, hearing day.
See, 5th my hearing.
Oh, okay. 5th of February 2026. This interlocutory application is accordingly disposed.
Oblige my lord. Highly obliged.
Item 22. Item number 23.
None has appeared for the petitioner on call. Let this matter be listed in the next week on a date to be fixed by the district.
7.
Wait, this your lordship. Lordship, my senior is unlike an another court. But matter mechanically pass over for time being.
Okay.
I'm sorry, maybe it was because of me you got.
No, not at all.
It's really.
Not at all. We'll take it up after something.
Your lordship. I am hearing on behalf of Deva Ahmed lordship.
What is this?
Delay in filing the second appeal lordship. There is delay 347 days lordship. The process is completed and the file they are affidavit.
You are objecting?
Lordship, yes, file objection.
Okay. Yes, what is your submission?
Lordship, due to medical ground lordship, the applicant number, the title appeal lordship, reference number 3 has been accepted. As such, there is some delay. Subsequently, some monetary problem lordship, we filed this appeal after delay 347 days. I wish to in paragraph 4 lordship in my petition IA lordship.
Yes. You were the defendant or plaintiff?
Plaintiff, yeah.
Your suit was
Dismissed.
dismissed. Suit was for declaration of right title in interest, as well as
Title appeal, this title appeal also been dismissed.
no. Yes. Para 4. Only financial hardship.
Medical and financial hardship.
What medical ground?
The applicant, number 3 lordship, expert lordship, so the other applicant were busy in the
What is there to show that you were ill?
applicant number, lordship,
Where is the medical ground?
ground lordship is also in the para 4 lordship. The applicant lordship is a 70-year-old lordship, and due to some medical lordship, he could not file the second appeal in due time lordship. Medical certificate lordship, annexure 1. Mr. B. lordship.
What ground you are taking in second appeal? What substantial question of law? What is your case in appeal? We'll take it up on some other day. Come prepared. He is not prepared.
That's why I have not gone through the appeal lordship.
Let him come prepared.
This is again concurrent finding of tax laws.
Yes, there are.
My lord, the delay lordship, the
No, delay is more delay, but he is not prepared.
loss.
Let him come prepared. Heard. Mr.
I'm just on behalf of.
MZ Shah, appearing on behalf of Mr. G.O. Ahmed. Because unless you come prepared, you have a weak case, very weak case. Also, Mr.
M.H. Ahmed,
M.H. Ahmed,
for respondent number 1.
for respondent number 1. Mr. G. Bora, for respondent number 2. Learned counsel for the applicant has submitted that he may be granted some time fully prepare the case before making his submission in this case. On the other hand, no, the learned counsel for the respondents does not raise any objection to his prayer. When? In the first week of January. Accordingly, let this case be listed in the first week of January on a date to be fixed by registry.
Item 29.
Hello, this review petition is, my lord, filed against the review of the judgment, my lord, lordship, my lord, that was passed on 10/11/2025 in CRP IO of 3005 of 2027. That review petition did CRP was, my lord, preferred against the two impugned orders, mine. Order passed in this case number 269 of 2025 and 270 of 2025, my lord. Both these orders are subject to challenge in this and that CRP, my lord. But my lord, from the orders passed to your lordship, it appears that my lordship only dealt with 269 of 25. There's no mentioning of 2070 of 20. There's no finding there on that at all in the chart. That chart.
Where is the impugned order?
So my lord will find 143, my. That's my lordship judgment. Possible, they'll be into it only 269.
Yes,
Your Lordship, we have not received a copy of review petition.
This is a review, my lord, after dismissal of our petition.
We would like to receive one, Your Lordship.
So my lord, notice may be issued at this stage, we'll serve you a copy, my lord. It may take about. We'll serve you a copy, my lord.
heard Mr. B.J. Ghosh, learned counsel for the applicant, learned counsel for the petitioner, also heard Ms. K. Sharma, learned counsel for the respondents. This review application under Order 47 Rule 1 of the CPC, read with Section 114 of the said code, has been filed by the petitioner. The review of the order dated 10/11/2025 passed by this court in CRP within bracket IO number 376/2025. Please, 375/2020. The main plea of the review petitioner in his application is that though the present applicant, by filing the CRPIO number 375/2025, had impugned order dated
29/8/2025.
29/8/2025,
In
passed
case
in Ms. J case number 269/2025,
And
as well as which order?
270 of same date.
As well as order dated 29/8/2025, passed in Ms. J case number 270/2025. However, by the order under review, this court only dealt with the order dated
269 of 25. Miss J case number.
29/8/2025, passed in Ms. J case number 269/2025, and have not considered the other impugned order passed on the same date in Ms. J case number 270/2025. Issue notice. Since Ms. K. Sharma has appeared for the respondents, no formal notice need to be issued to the respondent. However, the petitioner is directed to furnish a copy of the review petition to the learned counsel for the respondent. Registry, the record is there. The registry is directed to place the records of CRPIO number 275/2025 along with this case in the first week of January on a date to be fixed by it, list accordingly.
30.
Lordship, let me take this. Lordship, on the last date on 8/8/2025, the honorable court had passed an interim order staying the proceedings of the impugned order. In order dated 8/8/25, there is one mistake in the order. The lower court case number is changed. It ought to have been land grabbing case 6/2014. In the order, it is mentioned 6/2024.
You have taken steps.
Yes, sir. We had taken steps, but as per the last office note
1/11/25, it is mentioned that unserved notice returned with comment, no such address. But we have picked up the address from the lower court case. We may be allowed to take steps to the counsel in the lower court.
Where is the address? Let us see.
Page number 22. Annexure 2. This is the address we have picked up from the land grabbing case.
You take fresh steps by registered post, by speed post.
Speed post.
Heard, Mr. What is your name?
G. Kaushik.
G. Kaushik, learned counsel for the petitioner. It appears from the office note dated 1/11/2025 that the notice issued to registered post with AD to the sole respondent has returned without service with an endorsement within inverted comma, no such address, RTS inverted comma clause. Learned counsel for the petitioner has submitted that the address of the respondent has been mentioned after as it was stated in the records of land grabbing case number 5/2014.
6/2014.
6/2014. Stop. In view of the above, the petitioner is directed to take fresh steps for issuance of notice on respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
An observation for that.
Learned counsel for the petitioner has further submitted that though the further proceeding of MIJ case number 9/2025 arising out of land grabbing case number 6/2014 was which is pending before the Court of Learned Additional Session Judge Tinsukia was stayed by this court by its order dated 8/8/2025, however, due to typographical mistake, the land grabbing case number has been mentioned as land grabbing case number 6/2024 in the said order instead of 6/2014. So same shall be treated as no stop. Considering the submissions made by the learned counsel for the petitioner as well as considering the records, it appears that there has been a typographical error which is inadvertent in mentioning the year of the land grabbing case. Hence, in the order dated 8/8/2025, the land grabbing case number shall be read as land grabbing case number 6/2014 instead of land grabbing case number 6/2024. List accordingly.
Interim may be continued.
The interim order shall continue till
What's
next.
31.
May please, your lordship. Lordship, in this case, there are two respondents. For respondent one, the counsel has already appeared. And for respondent number two, ID card has not been received, lordship. So service may be awaited at this stage for respondent number two, lord. And
Heard Mr. R. Sharma, learned counsel for the appellant. Also heard Mr. What is your name?
NZ Chaudhary, lordship.
NZ Chaudhary, learned counsel for respondent number 1. It appears from
Office note dated 28/11/2000.
dated 28/11/2025 that the notices issued to respondent number 2 has not yet been received back. What will you do? We'll await.
Lordship. Apart from the lordship, one submission I paid to make is the lordship on the last occasion, the adjoining IA was direction to deposit 50% amount. That, as per our information, has been deposited in the registry. So lordship, for appropriate order may be passed for withdrawal of that amount, lordship. For that, they have to file an application, lordship. But they have not.
You file you file an interlocutory application, we will allow it.
We'll file the appropriate petition.
Await further. List this matter after 4 weeks.
32.
Lordships, IS for condemnation of delay. 20 days delay is finally appealed, lordship. And claimant is already appeared. For respondent number 4 has expired, lordship. He is the owner.
20 days delay, lordship, they come basically with the quanta. So owner driver is not necessary, lordship. I have no objection on 20 days delay.
Quantum owner is a necessary party.
We have to indemnify the owner, lordship.
The owner has expired.
13/5/2024.
Then you have to take steps.
Have to file substitution.
No, that's not necessary because quantum
In quantum,
that will in between the claimant and the insurance, lordship.
But honor is necessary party because we have to indemnify the owner, lordship. With the
In
insurance.
the appeal, lordship, they can regulate, lordship.
otherwise there is no stay. Stay is not there.
No. Appeal is yet to be registered.
Yes. Heard,
Let-
Mr.
Register.
Let them find out whether or is there any legal representative of owner. Heard, Mr. R. Sharma, learned counsel for the applicant. Also heard Mr. M. Khan, learned counsel for the respondent claimant. Learned counsel for the applicant has submitted that though this interlocutory application has been filed by the applicant insurance company for condonation of delay, for condoning the delay of 20 days in filing the connected MAC appeal. However, in the meantime, from the office note dated 25/11/2025, it appears that the owner, that is respondent number 4, has already expired on 13/5/2024. And in that regard, 13/5/2024 stop. He therefore submits that the applicant may have to take necessary steps for substituting the name of the respondent number 4 by his legal representatives. And for the said purpose, some time is prayed for. The prayer is allowed. How much time? Let this matter be listed after 3 weeks on a date to be.
Apply, Lordship.
Item 33.
In this case also, Lordship, 19 days delay. They have come with quantum.
Your Lordship, kindly peruse office note dated 25/11/2025. Service upon respondent 1, 2, 3, and 5 is complete. And respondent number 4 has expired.
What will you do?
Otherwise, service is complete, Your Lordship. And
Who is
this
respondent number 4?
4 is the owner of the offending vehicle.
Against quantum.
What is
And
your
we are-
submission?
We are challenging the quantum in this application. So, 4 is not a necessary part, Your Lordship.
Okay. Heard Mr. S. Datta, learned counsel for the applicant. Also heard Mr. M. Khan, learned counsel for respondent number 1, 2, and 3. On perusal of the office note dated 25/11/2025, it appears that the notice as issued to respondent number 5 has been served by handing over the same to the brother of the respondent number 5. Whereas notices issued to respondent number 4 could not be served as he had expired on 13/6/2022. Learned counsel for the appellant has submitted that the appellant insurance company is aggrieved mainly with the quantum of the awarded quantum of the compensation awarded to the claimant, and therefore he says, therefore the owner of the vehicle, that is respondent number 4, may not be a necessary party in this appeal.
I beg
And-
your pardon, Your Lordship. Only in the IA is not necessary. Otherwise, we have taken one ground where there is a
This
dispute,
I is for,
alternation of delay.
and this owner is not, may not be necessary party in this interlocutory application, which is filed for condoning the delay of how many days?
19 days, Your Lordship.
19 days. Considering the submissions made by the learned counsel for the insurance company, notice to respondent number 4 in this interlocutory application is waived. And stop. Further, considering the office note dated 25/11/2025, notice issued to respondent number 5 is held to be duly served. You have any objection? This interlocutory application under second proviso to section 173 of the Motor Vehicle Act, read with section 5 of the Limitation Act 1963, has been filed by the appellant insurance company for condoning the delay of 19 days in preferring the connected MSC appeal. Learned counsel for the petitioner applicant has submitted that the applicant has explained the delay
In paragraph number 4.
in paragraph number 4 of the instant interlocutory application, and praise for condoning the said delay. Stop. Learned counsel for the respondent claimant, considering the short period of delay of 19 days as well as reasons mentioned in the application, does not raise any objection to the prayer for condoning the delay. Stop. Considering the submissions made by learned counsel for both sides, as well as considering the grounds stated in paragraph number 4 to be sufficient ground which prevented the present petition applicant from preferring the connected MSC appeal within the prescribed period of limitation, comma, the delay of 19 days in preferring the connected MSC appeal is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected MAC appeal and list the same before the court after a week on a date to be fixed by it.
What's all?
34.
Please, Your Lords. Your Lords, I am for Guwahati liquidator of Guwahati Construction in this matter, Your Lords. It's a very short issue. Your Lords, may I submit?
Yes.
Yes, Your Lords. Your Lords, the
What-
company.
What this IA is for?
Yes, Your Lords. So, Lords, this is an application for relaxation of that order of 8th April 2024 passed by this bench, in which this bench has ordered that the status quo of the property, suit property be maintained. So, Your Lords, the background of this matter is.
8th April order was passed in RFA.
Yes, Your Lords. Yes, Your Lords. I have annexed that. It is annexure 1 in my application.
Page number?
Page number, Your Lords, 17, 18, Your Lords. Relevant is on 18, page number 18, Your Lords. Last line.
Yes, what is the
Yes,
case?
Your Lords. So, Lords, what has happened is in this respondent number 1, Guwahati Construction is in liquidation. This was, though it was first into CIRP on 24th March 2022, which is annexure 2, Your Lords, page number 19.
What is this?
Your Lords, this is a CIRP order. So this company went into insolvency, Your Lords. So proceedings against Section 7 were initiated against this company, Guwahati Construction, Your Lords. And moratorium was imposed under Section 14. So once a moratorium is imposed, no proceedings can be instituted against the corporate debtor. In this case, Guwahati Construction, Your Lords. So, Your Lords, before this company went into CIRP, there was a suit filed by filed by Union Bank of India, against which was dismissed ultimately by the learned trial court, and against which they came in appeal. So this was filed, and thereafter the company went to liquidation, CIRP, Your Lords. So, Your Lords, kindly have page number 8 of my application for a moment. Yes, Your Lords. Para D. As per scheme of IB code, inter alia section 17, 23 and 25, from the date of appointment of IRP. So, Lord, CRP was initiated and IRP was appointed. The management of the affairs of corporate debtor vested with the IRP. Further, the powers of board of directors were suspended. So, relevant portions, Your Lords, I have incorporated section 17 of the Insolvency and Bankruptcy Code. Your Lords, 17A, the management of affairs of debtor shall be vested in the interim resolution professional, Your Lords. Thereafter, Your Lords, page number 9.
What this IRP stands for?
interim resolution professional, your lords. So basically what happens, your lords, once the management is suspended, so he takes over the management and the entire process, controls the company so that it is sent to a different management. Ultimately, if the resolution is passed and he gives it to another company. So in the interregnum, he is appointed as a management of the company. So this is filed when the company is not the ultimate aim of IBC is to take away the company from a company management which is not able to run it properly and give it to a worthy person who can run it properly. So in the interregnum, the IRP is appointed, your lords.
Notice.
Your lords, may I continue?
No, why this regular first appeal was filed
After this, your lords, after the CRP order, after the liquidation order, and then they filed this RFA. Without impeding technically the liquidator, which they should have. They were very well aware that the company is under CIRP. Because this was bought before the knowledge of the trial court also. Your lords, order dated 3rd March 2023, your lords, annexure 3 of my application.
what is the legal provision regarding the CIRP?
Your lords, this is section 7 of Insolvency and Bankruptcy Code, your lords. Application was filed under section 7.
What it provides for?
You know, this is corporate insolvency resolution process. So basically, if there is a chance that the company can be revived, and so they take up the management from that current management and give it to some other. So the intent is to revive the company in insolvency and bankruptcy laws. So there are 3 ways in which company can be sent into CIRP. Section 7 is filed by a financial creditor. Section 9 application, which is filed by an operational creditor, and Section 10, which is filed by a corporate debtor itself. Saying that, okay, I am not able to run my company properly, you take the management from me and you sell it off to someone else. So the IRP collects all the claims from the creditors. So there is a moratorium imposed and no proceedings can be initiated against the company.
Who appoints this IRP?
NCLT, your lords. NCLT. Your lords, kindly have that order.
Where is that order?
Yes, your lords. The same order, 24th of March, page number 19. Your lords, the relevant page is at page number 29, your lords.
This Insolvency and Bankruptcy Code.
Yes, your lords.
2016.
Yes, your lords.
This is under what law? What is the Parent Act?
What's Yeah, this was an amendment because earlier there were other statutes also, Provincial Insolvency Act and others. So this was.
What is the status of this code? Is it a statute?
Yes, your lords. Yes, your lords. It's a statute, your lords.
Do you have a copy of that code? Of this Insolvency and Bankruptcy Code?
Your lords, I can screen share if your lords permit me for a relevant.
No, it will be difficult.
Please, I understand, your lords. So.
Okay, it is there.
Yes, your lords.
Section 7.
Yes, your lords. So CRP is initiated against corporate debtor under 7, 9, and 10, your lords. In this case also, Indian Bank, being a financial creditor, initiated this.
Yes, yes. What is your submission?
Yes, your lords. So let's kindly have page number 28 of my application. So that the relevant portion which says that there the company was under CIRP and IRP was appointed. So the order starts from 28, the relevant, the operative part. I'll just read you lords. Heard the
Just a minute,
counsel of the
just a
applicant.
minute,
Yes,
just a minute.
sorry.
This is order of
NCLT Guwahati Bench, your lords.
okay.
National Company Law Tribunal, your lords.
Yes.
Yes, your lords. Kindly have page number 28. The order starts from there, your lords. And the next page, your lords, 29. Para 14, just above para 14. Hence the present IB petition. Your lords has that?
Yes.
Hence the present IB petition is admitted. Insolvency and bankruptcy petition is admitted with the following directions and observations. The date of admission of this petition is 24/3/2022. As per the provisions of 13 and 14 of the date of commencement of insolvency, this adjudicating authority declares moratorium with effect from today for prohibition of all of the following, namely, institution of suits or continuation of pending suits proceedings against the CD, including execution of any judgment, decree, or order in any court of law, tribunal, panel, or authority, your lords. There are other, your lords. And then, your lords, kindly have page number 30.
This
these
order is passed on which application?
Your lords, this is an application filed by Indian Bank. I'll just, your lords, take you to the relevant part. Your lords, kindly have page number 20.
Yes.
Para 1, your lords. The present petition has been preferred by petitioner financial creditor, that is Indian Bank, under section 7 of IB code, read with rule 4, insolvency and bankruptcy adjudicating authority rules, seeking for initiation of corporate insolvency resolution process, CRP in short, in respect of corporate debtor, namely Guwahati Construction Private Limited.
Okay.
Yes, your lords. Your lords,
Which
now
is the petitioner before us?
yes, your lords.
Okay.
So, no, your lords, these are not petitioner. Union of India is a petitioner before your lords.
No, this interlocutory application has been filed by.
This is filed by this IA 2022, your lords, has been filed by the liquidator of Guwahati Construction.
Okay.
I'll reach to that, your lords. So your lords had raised a query appointment of IRP. So page number 30, your lords, para 15. Page number 30. This adjudicating authority hereby appoints, your lords has. Yes, sir. This adjudicating authority hereby appoints as proposed by the FC's financial creditor, your lords, Mr. Purushottam Gaggar, P. Gaggar and Associate Chartered Accountant, address, your lords, as the interim resolution professional. The interim review is further directed to make public announcement of the moratorium in respect of the corporate debtor soon after the receipt. So, your lords, moratorium is section 14, which I had read earlier. Moratorium in respect of corporate debtor soon after the receipt of authenticated copies of this order. And your lords, 13 and 14 will come into play. Your lords, and then para number 31, page number 31, para 16. The IRP is hereby advised to adhere to the time limit as stipulated for completion of the CIRP and perform its duties as specified under section 17, 18, 20, and 21. You know, 17 and all says that the 17 says the management was suspended, and 18, 19, they talks about the duties of the IRP, that the IRP can represent the corporate debtor in every litigation and he will do everything required to run the company smoothly and for the entire CIRP process.
Okay.
Yes, this factum was brought before the learned trial court, and an order was passed to that effect on 3rd of January 2023, in which Union Bank was already a party. Union of India was already a party. So they had filed a suit against the corporator pertaining to a land, saying that that land belongs to the railways, Union of India through railways. So during this pendency, first para, bottom 5-6 lines.
Page number?
Page number 33, lords. The order of trial court on 3rd of January 23.
Yes.
Yes, Lords. So we place this order before the trial court to tell the trial court that okay, CRP is initiated, moratorium is imposed, and now the IRP will represent the. Then he became the resolution professional. The resolution professional will now represent the company in these proceedings. Why they submitted Indian Bank file an application this before Honorable NCLT against defendant number 1 for insolvency being case number this. That the NCLT white order dated 24/3/22 admitted the petition and declared moratorium with effect from 24/3/22 on the subject mentioned in the order dated. That Shri Purushottam Gaggar was appointed as the IRP by Honorable Company Law Tribunal and direction was also passed to make public announcement of the moratorium in respect of the CD. Then Mr. Burr, being appointed as IRP by the Honorable NCLT, has to represent the affairs of CD, being the defendant number 1 in the instant suit. In view of the above, prayer has been made to allow the IRP, Shri Purushottam Gaggar, to represent the defendant number 1 in the instant suit in accordance with order dated 24/3/22, passed by the Honorable NCLT in case number this. Then the last para, I will not read all. That being the position I deem fit and proper to allow the prayer of the defendant number 1, accordingly, Shri Purushottam Gaggar, the IRP, is allowed to represent the defendant number 1 in the suit. So, this was in their reply, since I will come to that, union says that they were not aware and these proceedings and they are not bound by these proceedings of the NCLT. So, I was just bringing this to your Lord's attention because these proceedings are in rem, your Lords. The CRP proceedings and the liquidation proceedings are in rem. Because it cannot be that you give the company to a new management and ask them, it's a clean slate theory is applies to these companies laws once it has a resolution is passed or a liquidation order is passed. Thereafter, on 10th February 23, liquidation order was passed. Page number 35. Since resolution could not happen in the company, so resultantly, the company went into liquidation. The relevant page is at 44. Yes, para 9.1. Prayers are sought for the IA, this filed by Mr. Purushottam Gaggar, the RP of the corporate debtor, Guwahati Construction, is allowed and corporate debtor is ordered to be liquidated in terms of section 33(2) of the code read with subsection 1 thereof. Mr. Purushottam Gaggar, having address, he is hereby appointed as liquidator as provided under section 34 of the code, subject to his possessing a valid authorization that he had, your lords. And then, your lords, the parent 9.3, the COC under regulation has recommended the sale of the CD should be as a going concern. The liquidator is directed to adhere to it. And thereafter, your lords, para 9.6, all the powers of the board of directors and the key managerial person shall cease to exist in accordance with section 34 subclause 2 subsection 2 of the code. All the powers are vested henceforth with the liquidator. So similarly, your lords, whatever the management is still suspended and liquidator continues with the process, your lords. Okay. So the same person was appointed, the RP was appointed as a liquidator, lords. So what happens in after liquidation order, a stakeholder consultation committee is formed and all the creditors file their claim, and accordingly the assets of the corporate debtor or the company are sold and distributed amongst the stakeholders, your lords. So in this issue, the point of contention in this matter is the development rights on the land, which is the suit property. So the corporate debtor only has a development right on that land. So I am just seeking that let me sell the development rights with all the litigation and consequential consequences to a third party so that I can close the liquidation. Because of this pending liquidation, I am not able to close the liquidation of the company. You lords kindly have. So this was discussed in the 7th SCC meeting. You lords, Annexure 5, page number 47, it starts. And 48 is the relevant discussion. Your lords. So the liquidator tried to sell the lands in this matter, the land, but the development rights, your lords. But since there was a dispute initiated by a union in this, so they could not be sold. So there is a provision when that you cannot sell it by a auction or something. So there's a provision of NRRA, non-readily realizable asset, that you sell that asset as an NRRA with all the litigation and everything, and let that person take that risk of whatever litigation is happening, so that you can close the liquidation. Otherwise, since if the asset is with the company, so you cannot close the liquidation. It has to be zero. Only then the company will be dissolved. So in this discussion has happened, the liquidator updated agenda number 4. The liquidator updated, they tried to dispose the assets of the corporate debtor through public auction, and public auction notice was published twice. Your Lords has 48. Yes, Lords. Process preside under IBBR regulation. However, no response was received from prospective bidder for acquiring the assets through the auction. Your Lords, thereafter, the next to next paragraph, the liquidator obtained legal opinion and hence said that this can be sold as an NRRA, non-readily realizable asset. So this was a provision given in IB code so that the liquidation can be closed. Otherwise, if this litigation keeps on going till Supreme Court, your Lords, ultimately this might. So the liquidation can never be closed.
What is NRRA?
Non-readily realizable asset, your Lords. So
what it
yes,
means?
Usually what happens is, for example, if there is a car, I can sell that car and take that money. But if there is a litigation on that car, I am not able to sell that car. So what happens is, I will sell that car with all the litigation to a third person. That, okay, it's like assignment of debt, your Lords. That I'm assigning it to you, you take care of the litigation, and I will sold, for example, the value of the car is, let's say 50 lakh rupees, I will sell it to that person for 10 lakh rupees.
So its asset is realizable.
Non-readily realizable asset, your Lords.
It is not ready for realization.
Yes, your Lord. Yes,
dependent upon the outcome.
Contingency. Yes, outcome of the litigation. That's why, your Lord.
Okay.
So this was a provision, and they decided that to sell it off as a NRRA, which is Regulation 37. Your Lords, the second last para from the bottom. The matter was discussed, and the committee was of the view that since both the properties are NRRA, the liquidator may proceed to dispose the assets as per the provision of Regulation 37 of the liquidation regulation, your Lords. Your Lords, thereafter there was a bidder. We tried to sell it to that bidder, but he defaulted in that payment, and we have filed an application before NCLT for confirmation of that auction also. But since he could not deposit the entire money, so that bid was cancelled. Your Lords, that is page number 50 of my application, that order. Yes, Lords. Your Lords, I have page number 50. May I read?
These are orders of
NCLT, your Lords.
NCLT.
Yes, your Lords. That's the adjudicating authority. So the CIRP and the liquidation proceeding, every proceeding has to be before the NCLT. And that is so after NCLT, if a person is aggrieved, he goes to NCLAT, a National Company Law Appellate Tribunal. This is an provision of
this consultation committee.
Yes, sir. This SCC is formed, they are all the stakeholders. So all the creditors, the operational creditors, the financial creditors, they file their claim from all over India. If they have any claim against the company, they file their claim before the liquidator, so that a holistic view can be taken and the company can, otherwise, your Lords, if there is any litigation pending, you cannot really close the company. So, your Lords, page number 50 is I had filed an application, this IA 42, for selling the asset, the development right as an NRRA. But since the bidder failed, so I had to withdraw that application. It became infructuous. Mr. N appears on behalf of the liquidator and seeks oral permission to withdraw the application, as the same has become infructuous on account of the bidder withdrawing from the bid permission. From the bid, permission is granted, IS disposed of as withdrawn. So NCLT was considering this. I was on the verge, but since he withdrew, he could not deposit the amount, so I had to withdraw that application. Now, your Lord, thereafter, this judgment was passed on 19th January, the impugned judgment pertaining to the RFA laws. I'm now on the RFA laws. On 19th January 2024, this suit was dismissed and it was passed in my favor, your Lords. This was suit filed by Union Bank on a subject property, suit property. This was dismissed and it was awarded in my favor, that the land does not belong to the Union Railways and it belongs to the individual who had mortgaged or whatever, your Lords. And there are some development rights which were given by these individuals to me. So now I am before these laws because there was an order passed to maintain status quo. Now I am before the laws to only seek permission that let me sell this land for the development rights with the litigation and everything. Kindly have my prayer at page number 45, your lords. Page number 15, sorry. Page number 15, your lords. Sorry, I'm sorry. Pass appropriate, they were permitting applicant liquidator to assign the assets of this as an NRRA on as is where basis with all the litigation. Your lords has this? Page number 15.
Yeah.
Yes, your lords. In the premise, you praise that pass an appropriate order, thereby permitting the applicant liquidator to assign the assets of Guwahati Construction as NRRA on as is where is basis with all the litigation and encumbrances on the said asset and or pass further orders, your lords. So, lords, I do not know what's the difficulty with union of me selling because ultimately I have to close the liquidation. Liquidation period is usually 180 day, 1 year, your lords. Now, if you see, your lords has seen that the liquidation order was passed in 2023, 10th February 2023. Because of this stay, this order of 8th of April, I am not able to sell because otherwise I will be inviting a contempt. Even though I can sell it as already given, IB code has given me that right to sell it as an NRRA, I'm still not able to sell it and close the liquidation.
Okay. So you
That's my
want the status quo order to be modified?
yes, your lord, so that I can
The-
at least sell the
the-
development rights and close the liquidation.
Yes. Anything else?
No, your lords, if I can go to cause of the only contention which they have taken is that okay, this will create third party right and which will cause prejudice to them, which I've already taken care of, saying that I'm the person, the next person I will sell it to, he will step into my shoes and he will take care of the litigation. There will be no multiplicity of litigation as such. So that's their only contention, that there will be multiplicity of litigation in this. And I'm not selling the suit property laws. I'm just selling the development rights, whatever assets the corporate debtor has. That's it. Because ultimately this is affecting the financials because the creditor stakeholders are Indian bank. It's a public bank, your lords. Ultimately, they will have to other unnecessary shell money for litigation in this. So they just want to sell it off and just get rid of this. And the next person will come and continue with the litigation. That's my contention, your lords. Now union can, your lords, continue there.
The company law tribunal
Yes.
had allowed you earlier.
Your lords,
So-
I had filed my application, but the bidder withdrew. So that's why I had to, that application became infructuous. So there's a provision given in IB
So
code.
now you, even if you want to sell it again, you have to obtain leave
Permission
of
from the, your lords,
company
yes.
law tribunal.
No, lords, I have to first modify this order because otherwise if I sell it.
Suppose the status quo order is modified.
Yes, your lords.
Then also you have to
Yes, your
obtain.
lords. Yes, your lords. I will have to go to NCLT. I will have to seek their permission that, okay, this is the person, I am selling it and kindly allow me to assign it to a third person. Then NCLT will take into consideration.
Under section 7.
You know, section 7 is the initiation. I will file, I have to file that application under regulation 47, your lords, of insolvency and bankruptcy. Your lords, I had read that in that minutes of meeting. So there's a provision given for me to file an application.
Yes, Mr. Chakravarti.
Lordship, can you see, Lordship, can you peruse our reply, Lordship, page 89. It's a copy of the Chitta, Lordship, the relevant Lordship, Dag number 208. 208 is the Dagin issue. And what is the remarks column, Lordship, may kindly see?
Page number?
89. It will be continuation of that, Lordship, reply to the IA. It will be in the IA, Lordship. Our reply, page 89. Chitta copy, Lordship.
There is no page 89.
IA will be.
I'm taking up.
2202. IA 2202. Perhaps my reply has not come into the record, maybe.
Your reply, is it on record?
I haven't checked out. Lordship.
When have you filed?
5/9/25,
Oxley?
September.
What is your name?
Nirmal Goenka, Your Lords.
From where you are?
Your Lords, I'm from Delhi.
Okay.
The roots belong to.
So the respondent number 1 has been declared as bankrupt. by the-
Your Lords, not bankrupt. It's as in insolvency proceedings initiated to revive it. So bankrupt says that, okay, this company does not have anything. So it's an insolvency proceedings
And
are.
the company has been liquidated.
Yes, Your Lord, liquidation proceedings are going on. I'm not able to close the liquidation. Only this because of this litigation. Liquidation proceedings are going on now.
That is not in the
The
record, Lordship.
record is, the objection
I
is,
sent copy to the other side. Mr. M. Sahiwala received that copy.
I have the copy of the reply. I'm not saying
But-
that I did not.
but that copy has to be there with the, you have an extra copy.
Right now. Lordship, may Paris that, page 18.
Or we will direct the registry to place the,
Lordship,
we'll fix it in the next week.
Lordship.
Your Lords, otherwise they are going on. I'm just saying that they are going on merits. I'm just asking them what is their contention pertaining to me selling it as as in going concern or with all the litigation. That's the only thing they have to answer.
Litigation, Lordship. Third
No,
party right
no,
will be given to
we
someone
will
be
consider your submission. But let the objection be on record.
Please, Your Lords.
When can we fix it?
Your Lords, after, not on 10th, Your Lords, any day after 10th. 16th, Your Lords, if convenient, Your Lords.
Twelfth.
12th. Your Lords, can it be 15th? 12th, I'll take my chance, Your Lords. 12th is fine. I'll take my chance.
Heard Mr. N. Goenka, learned counsel for the applicant, appearing through video conferencing. Also heard Mr. B. Chakravarti, learned central government counsel, appearing for opposite party number 1. This interlocutory application has been filed by the applicant, who is the official liquidator of Messrs. Guwahati Construction Private Limited / corporate debtor. Praying for, what is your prayer?
Yes, Lords. Lords, permit me to assign the assets of the corporate debtor as NRRA on as is various basis with all the litigation and encumbrances.
To allow, to assign the assets of the corporate debtor, Messrs. Guwahati Construction Private Limited, as non-readily realizable assets within bracket NRRA on as is various basis with all litigation and encumbrances of the said assets. Learned counsel for the learned central government counsel, Mr. B. Chakravarti, has submitted that the Union of India has filed a written objection opposing the prayer of the applicant, however, it appears that the said written objection is not on the record. The registry is directed to place the said written objection on record and list this matter again on 12th of December 2025.
Highly applied, Lords.
Item 36 piece of material. Yes. Yes.
May I please, my lord, this I is filed for allowing us to take substitute mode of service by make paper publication, my lord, for 8 responded, my lord. Despite several steps we have taken, we could not serve them. Therefore, we are praying that we may be allowed to make paper publication. At para 3, page 13, my lord, we have given that we may be allowed to take step for number 8, 11, 13, 17, 20, 22, 24, and 25.
Any objection?
Your Honor, I am appearing on behalf of Advocate M.H. Lester for respondent 4.1, 4.2, 4.3, respondent 5 to 7, respondent 8 to 10, and respondent 14 to 16.
Others they appear. One,
I for 1 and 1 to 3. Don't have any objection.
No. Mr.
SK Chakraborty.
S.K. Chakraborty. London. Counsel for the applicant. This I is for,
Paper, making paper publication.
and at what stage RSA is pending?
Huh?
The second appeal is pending at what stage?
No, my lord, for hearing. LCR has come. Only for service. The service is not complete, that is why, my lord.
Service is not complete. RSS now?
It is already admitted. my lord. Several steps has been taken by.
RSA. RSA. Heard. Mr. S.K. Chakraborty. Learned counsel for the appellants. Also heard Miss, what is your name?
S. Chaudhary.
S. Chaudhary. Appearing on behalf of Mr. M.S. Laskar, learned counsel for respondent number
4824C.
4.1,
4824C,
8 to 10, and 14 to 16.
5 to 7,
Eight.
8 to 10,
8 to 16.
and 14 to 16. Also heard Mr. T. Gogoi, T.R. Gogoi, learned government counsel appearing for respondent number 1 to 3. Learned counsel for the appellant has submitted that the appellant has filed an interlocutory application, which is registered as IA Civil number 3506/2025, wherein a prayer has been made for allowing the petitioner, for allowing the appellant to take steps for issuance of notice upon respondent number 8,
No, my
comma,
lord. My lord, my learned friend has just submitted that she is appearing also for 8. The 8 may not be required there. 11,
for
13,
11, 13,
17.
17, 20, 22, 24, and 25. As in spite of repeated attempts, the notices, service of notice upon the aforesaid respondent could not be effected. Learned counsel for the respondents does not have any objection to the said prayer. After considering the office notes as well as the report of the process server in respect of notices issued to respondent number 30, 11, 13, 17, 18, 20, 22, 24, and 25. It appears that the notice could not be served on the aforesaid respondent for various reasons. Therefore, the appellant is allowed to take steps for issuance of notice upon the aforesaid respondent by substituted mode of publishing the notice in 2 newspapers circulated in the area where the respondents are stated to have resided. Aforesaid respondents have stated to be resided. Stop. The appellant is accordingly directed to take steps for issuance of notice through substituted mode by publishing the notice in the newspaper, 2 newspapers within.
Northeast Express, my lord, and Dainik.
No, you choose the
Oh,
newspaper within 15 days from the date of this order. Stop. The date of notice in the date of appearance to be mentioned in the notice shall be 22nd of January 2026. List accordingly. Stop. RSA, ayat likhibu. In view of the orders passed today, that is on 5th of December 2025, in the connected regular second appeal, this interlocutory application has become infructuous and accordingly disposed of.
But since LCR has come, madam, I fixed for hearing in 6 days.
No, first notice has to.
Sorry.
Item 36.
Oblige, Your Honor.
Seven, my lord, I am for the respondent, my learned friend for other side, he want to withdraw this petition.
I have an instruction to withdraw.
Withdraw.
37, my lord,
37.
36, 37.
Heard Mr. B. Kaushik, learned counsel for the petitioner. Also heard Mr. T.J. Mahanta, learned senior counsel assisted by Mr. A. Burra, learned counsel for the respondent. Learned counsel for the petitioner submits that the petitioner does not want to pursue this matter and may be allowed to withdraw this instant civil revision petition. Stop. The learned senior counsel for the respondent does not have any objection to the said prayer. Hence the prayer is allowed. This civil revision petition is accordingly dismissed on withdrawal.
Stay order pass any earlier shall be difficult.
The stay order, if passed earlier, shall remain vacated.
Objection.
Yes, be short.
May I please, your lordship, we have filed for visitation rights of the child who's as of now, as on today, 8.5 years of age, who's not been allowed to have any physical access to his mother for a period of time, your lordship. And that we've asked for visitation for the child during the summer vacations, your lordship, in Guwahati, which is commencing from 20th December to